all participants may return to the main room as we will proceed to the announcement for the teams that advance to the final round. Now that all participants are back to the main room, we will now announce the teams that make it to the final round. To Aliandra, the time and screens are yours.
All right, thank you so much, Mr. Adit. Without any further words, I'm now going to announce the team that made it to the final round. The first team that will proceed to the final round is Team 101. Congratulations, Team 101, for making it to the final round. Moving on, the second team that made it to the final round and will proceed to the final round is Team 102. Congratulations, Team 102. And once again, congratulations for both teams. Before we have 30 minutes time for delegates preparation, we will have to pick a side for both teams. For this, we will do a coin toss to decide which teams go for claimant and which team go for respondent. To Team 101, you have the privilege to choose whether you want to go with head or tail. You can unmute yourself and answer. For Team 101. All right, Team 101 goes for head, which means Team 102 will go accordingly to tail. All right, without further ado, operator, you can flip the coin now. All right, it's decided. Team 101, which side are you going to choose for the final round since you chose head? Okay, Team 101 chose to go with claimant, which means Team 102 will go with respondent. All right, it's decided then. Let me conclude it for you once again. The team that made it to the final round is Team 101 and Team 102. Team 102 will be the claimant and Team 101 will be the claimant and Team 102 will be the respondent for final later on. To delegates that made it to the final round, don't forget to check your email for the opposing team's memorandum. For that, I'll leave back the floor to Mr. Adit. Thank you.
All right, thank you, Aliandra, and congratulations to Team 101 and Team 102 for making it to the final round. Now, as it's previously mentioned, the participants will be given 30 minutes to prepare for the final round, and you may not leave the Zoom meeting. The final round will be done here in the main room, so anyone can see it if they please, and it is open for public. Thank you, and we wish you all the best of luck.
Thank you. Recording stop.
All right, welcome back, participants. Since the teams that made it to the final rounds have already joined the Zoom meeting, we will now proceed to the final round. For the bailiff of this round, the time and screens are yours.
Okay, thank you, MC. Thank you, MC. Now we will move to the final round. But before we move to the final round, I would like to ask for the delegates and participants to fill the time allocation form that is will be provided in the chat box. Here is the time allocation for the claimant. For the claimant team, you may fill the time allocation form in the chat box. And here is the time allocation for the respondent, and for the respondent team, you may fill the format in the chat box. We will wait for you to confirm the time allocation in the chat box. Thank you. I see both of the respondent and claimant already filled the time allocation format in the chat box. For the timekeeper, you may confirm all of the time allocation for the share screen. And because all of the arbitrators are here now, I would like to confirm if the panels are ready. For Mr. Theodore Baker as the presiding arbitrator, are you ready to start the final round? I apologize, Mr. Baker. Your mic is not open yet.
Just filling in the names on the score sheet now. One of them done claimants.
Sorry, the sound is not very clear.
Okay, is this better?
That's much better. Beautiful.
I should simply speak loud, I think.
And okay, for Mr. Robert, are you ready to start the final round? I apologize. For Mr. Robert, are you ready to start the final round?
Yes, I'm ready for action.
Okay, for Mrs. Prita Amalia, are you ready to start the final round?
Sure.
Okay, thank you. For Mr. William, are you ready to start the final round?
Yes, I'm ready.
Okay, thank you. And for Mr. Glenn, are you ready to start the final round?
Yes, I'm ready. I'm just concerned with I think there's echo or something. Then it will be repeated and repeated.
Echo. I apologize. Can you repeat that, Mr. Glenn? I apologize, Mr. Glenn. I want to ask again. Are you ready to start the final round?
I've responded, but the voice just keeps repeating.
I apologize. I think this is it is my connection.
I keep hearing the same thing again and again.
But you are audible in my Zoom right now.
Okay.
Yeah, it's not very clear, but it's audible.
Okay, now move on to the claimant and respondent team. For the claimant team, are you ready to start the final round?
Yes.
Okay, thank you. For the respondent team, are you ready to start the final round?
Yes, we are, bailiff.
Okay, now we will start for the final round. Good morning, ladies and gentlemen of the tribunal. My name is Desliana Maharani Nurfitri, and I will be your bailiff for today's proceeding. And today's arbitration concerns about the purchase and sales of Nixon X1 series, and disputing parties are the claimant, Nixon Trains PLC, and against the respondent, Rihanna Rails Ltd. And the presiding arbitrator in this final round is Mr. Theodore Baker, with co-arbitrators Mrs. Rita Amalia, Mr. Robert Reid, Mr. Glenn Wijaya, and Mr. William Chindrawa. And after this, I will give the floor to Mr. Theodore Baker as the presiding arbitrator, and you may start the pleading session. Thank you.
Well, good afternoon, everyone. Welcome both teams to the final. You have successfully passed through the preliminary round and through semi-final. And now you are expected to give that final extra dedication, concentration, and alertness that's required for you to win the finals. We are on the bench. We have high expectations of what we're going to hear because of our experience in the previous rounds. And the fact that you came out best in those rounds gives us that expectation. We know already that it will be a very close race between these two teams because you've reached this stage. For us, we have one overriding duty, and that is to be fair to each team and to treat each team equally, and we are fully committed to that. So I think now is the time that we should see the sequence of presentations. Have the parties agreed? I see it now here on the screen. And do the parties agree to this sequence? If I don't hear any objection, I assume that that is the case. Okay, I think we're ready to go. There's just one final remark that I have, and that is we consider it to be duty of being fair that we also insist on the rules being followed, and that goes particularly for the time allotted to each oralist. Please strictly keep to that. But I will say that if the questions during a particular presentation are long and excessive use of your time, but please do that before you've reached the end of the allotted time. Okay, with that, I think we should make a start. I wish both teams a lot of success. You're going to need it because both teams are, as I said, equal to each other. But let me give the floor now on the procedural side to the respondents. Please go ahead.
Good afternoon, members of the tribunal. My name is Marfo Limardo, and along with my co-counsel, Ms. Alicia Hadiutomo, appearing before the tribunal on behalf of our client, Rihanna Rails. I will be addressing the issues for 9 minutes and will then be resumed by my co-counsel for 13 minutes on the remaining merits. Before the counsel begins with the submission, we will submit that our client has agreed on the tribunal's jurisdiction and will comply with any final award. Now, we will divide our submissions into 2 main points. First, that the tribunal had the jurisdiction to order security for cause. Second, that the respondent has fulfilled all of the prerequisites in applying for a security for cause. Proceeding to the first point, where Article 19, subsection 5 of the binding rule states that the tribunal shall have the authority to order any interlocutory decisions, including decreeing a security attachment. The tribunal in this context shall be entitled to require security for costs of any such measures. And as the parties had agreed to apply the law of Rihanna in the present dispute, which had adopted the UNCI trial model law, the parties shall also consider the standard contained in Article 17A of the model law.
Counsel, quick question for you. So are you
Yes.
basing on the law of Rihanna for the lex arbitri of this present tribunal, counsel?
Yes, we will agree to that, Mr. Arbitrator.
Are you sure about that, counsel? Isn't the seat of arbitration the determining factor for the lex arbitri and not the law of Rihanna, the governing law of the contract?
Well, to answer your question, Mr. Arbitrator, I will invite you to turn into page 8 of the record, specifically Article 21 regarding dispute resolution. Now, if the tribunal is with me, we can see here that the agreement is governed by the law of Rihanna, and therefore the law of Rihanna is the verbatim adoption of the UNCI trial model law, Mr. Arbitrator.
Are you certain about that, counsel? Isn't the law of Rihanna the verbatim adoption of the UNDROID principles instead?
Yes, to clarify, let me redirect the tribal's attention to turn to page 29 of the record. Process order number 1, subsection 3. And we can see from the 4th bullet points that Beatrix, Rihanna, and Costa Nomica's arbitration law are verbatim adoption of the UNCI trial model law, Mr. Arbitrator. If the council may proceed with the rest of its submission, it is established that in matters of granting interim measures, the requesting party shall satisfy the tribunal that first, harm not adequately reparable by an award of damages is likely to result if the measure is not ordered. Second, there is a reasonable possibility that the requesting party will succeed on the merits of their claim. Members of the tribunal, we are aware that the opposing counsel had submitted that our client had not fulfilled the standard contained in Article 17A. But in any case, before the tribunal shall apply any of the provisions contained in the UNCI trial model law, we shall first consider its international origin. The council submits that under Article 2A of the UNCI trial model law, that in the interpretation of any provisions under the convention, the party shall also consider the international origin of such laws.
Counsel,
Yes.
in the beginning of your submission, you mentioned about Article 19.5 of the Bani Rule. Is that correct?
Yes, Mr. Arbitrator, is that
And
correct?
why aren't we dealing with that first? Like dealing with the Bani Rule first, and let's see whether Article 19.5 is relevant in this case.
Where Article 19.5 of the Bani rules states that the tribunal, the Bani tribunal, shall have the authority to order security for costs and to apply the standards. In applying for a security for costs, Article 17A in this case will be applicable, Mr. Arbitrator.
And counsel, what about Article 36, for example, and 39? Are they relevant as well in this case?
Well, it is. I will clarify that it is our submission that we are only considering the applicability of Article 17A and Article 19, subsection 5 of the Bani rules, Mr. Arbitrator.
So you don't consider the applicability of Article 36 and 39 of Bani Rule?
36. Now, if the council may take a moment. Mr. Arbitrator, if I may clarify, it is Article 36, payment of expenses. Right. We shall clarify that in the application of a fixed, my apologies, of security for costs, we shall only consider Article 19, subsection 5 of the CISG as the application of interlocutory decision, and
CISG
Article
or Bani Rules.
My apologies, Bani rules, and Article 17A of the UNCI trial model law, Mr. Arbitrator.
Counsel, to clarify on my co-arbitrator's question, in regards to the allocation of costs, if you pay attention to Article 37 of the Bani Arbitration Rule, it is stated that in the event that both parties are liable for their claim, then the cost will be split among the parties in a proportionate manner. In that regard, counsel, when it comes to ordering security costs for respondents' legal costs in the event that the claimant loses this proceeding,
in the event that the tribunal rules in favor of respondent, how would you allocate the costs among the parties?
Well, we will submit that our submission for the procedural issue shall be granted, and that if the merits of this claim are successful, we will seek reimbursement for our legal costs incurred in this arbitration, Mr. Arbitrator. And if the council may proceed, therefore, by looking into its financial statements, we can conclude that claimant will be unable to satisfy any future cost award and will therefore avoid enforcement of such award. And to prove this, allow the council to invite the tribunal to turn to page 32 of the record, question 12, where claimant's financial statements is located. The cash-on-cash equivalence of claimant, according to their financial statements, is decreasing from $380,000 to $320,000 in the last 2 years, whereas the amount that respondent requested is at least $350,000. This raises questions of their ability to actually satisfy any future award rendered against them. It was also in this context that the opposing counsel is trying to assert that claimant had ultimately $5 million worth of intangible assets. However, member of the tribunal, we will clarify that intangible assets were only prospective assets. In other words, non-liquid assets. Therefore, these numbers will not suffice to presently prove claimant's capacity to pay any future cost award. Furthermore, it has in fact failed to comply with an award issued against them, and we can see this reference on page 26 of the record, Respondent Exhibit R7.
Counsel?
Yes.
Is there any time limit to pay for the cost?
Not that I'm aware of, Mr. Arbitrator, as the record has not shown had not provided us with the time limit.
No, I mean, in terms of is there a rule when should claimant pay out the award, right? Because you're so concerned that they cannot pay, and they then respondent needs the security.
Yes.
So is there any urgency?
Well, we submit that as our client had fulfilled Article 17A of the Mochtar Model Law, members of the tribunal, claimant's track of non-payment and their financial health act as the primary factors in awarding security for costs. Respondent concludes that claimant action would suggest that the claimant is most likely unwilling to comply with the financial implications of any future awards, and this will conclude our submission for the procedural issues. Thank you, members of the tribunal.
Well, thank you, respondents. We will now move to the claimants on the procedural side.
Good afternoon to all the honorable members of the tribunal. My name is Kanza Octalifia Kari, along with my co-counsel, Sarah Milenia, appearing before this tribunal on behalf of my client, Lisan Trains, as the claimant. I will be addressing the first issue with a total time of 10 minutes, and will respectfully reserve 1 minute for some rebuttal. Proceeding to the first submission of whether the tribunal has the power, and if so, should it order claimant to provide security for respondent's cost. Members of the tribunal, we submit that the tribunal indeed has the power to adjudicate the case. However, it should not order claimant to provide security for cost. Therefore, we divided the first submission into two parts. First, that the tribunal holds jurisdiction to hear the case. Second, that the tribunal should not order claimant to provide security for cost. Turning to the first point, allow the counsel to take the tribunal to page 7 of the record. Now, if the tribunal is with me, on May 18, 2022, claimant and respondent signed the purchase and sales agreement, hereinafter referred as the PSA, as a purpose to conduct the development of Convent Brianfos train, hereinafter referred as the CRFT. Claimant, as a seller, must produce and sell trains to respondent at an agreed price. However, respondent, as a buyer, refused to pay, leading to this arbitration proceedings. Members of the tribunal, we submit that the tribunal holds jurisdiction to hear the case as the parties in this dispute have validly agreed on the jurisdiction of the tribunal under Article 21 of the PSA, which corresponds with Article 1 of Bani Rules that stated a written agreement comprising an arbitration clause shall be treated as an arbitration agreement and be referred under the rules of Bani, then such dispute shall be settled under Bani. Continuing to the second point, members of the tribunal, we submit that the tribunal should not order claimant to provide security for costs, since respondent failed to meet its burden of proof in granting security for costs under the UNCITRAL Model Law on International Commercial Arbitration, hereinafter referred as the Model Law. Article 17 of the Model Law may permit the tribunal to grant interim measures. However, there are some exceptional circumstances in order to be granted security for costs, such
Counsel,
as
before you get into the prongs of your threshold or test that you're proposing, what are the costs that respondent is requesting a security for?
it is the cost of the arbitration costs and the damages.
Can you be more
Compensation.
specific? What cost?
The legal cost of this arbitration proceeding, Mr. Arbitrator.
Is it only the legal cost, counsel? Are you sure about that?
Yes,
Can you direct the tribunal to the page on the record where it is stated that the cost that respondent is requesting a security for is legal costs?
the tribunal may have a moment.
Yes, please.
In the record, they did not imply the legal cost to be the cost that the claimant has to pay. However, they imply that there is an unrepairable damage that will happen if the tribunal did not grant the request for security for cost, Mr. Arbitrator.
Counsel, how about on exhibit on page number 25 on the record? I think it is mentioned on respondent's request for security for costs that they are requesting security for the services of their lawyer and also expenses for inviting the witnesses and experts. So isn't that the cost, counsel? It's very specific there. Or
Yes,
you
that is correct, Mr. Arbitrator. My apologies.
okay, so how would you allocate the cost, counsel, according to the Bani arbitration rule?
In accordance with the Bani Rules, Article 37, the tribunal should decide the allocation of the expenses, Mr. Arbitration.
Are you sure about that, counsel?
But the tribunal, in general practice, they usually allocate 100% of the cost to the losing party.
Which article, counsel?
37, Mr. Arbitrator, of the Bani Rules.
Okay, so how about Article 38 of the Bani Arbitration Rule, counsel, for the legal service fees? Isn't the party to the dispute before this tribunal obligated to bear their own legal representation costs? So it's not gonna be allocated to the two parties. In the event that one of them loses, it doesn't matter. The party who bears the legal cost should be the party who uses that legal representation.
I believe it is stated if there is an invariable claims, Mr. Arbitrator. However, we submit that claimant does not have any invariable claims in this case. If the council may proceed, there are some exceptional circumstances in order to be granted security for costs, such as fundamental changes in the claimant's financial situation, and if a party's insolvency is proven by the applicant of the request. Allow the council to take the tribunal to page 26 of the report. Now, if the tribunal is with me, the respondent relied on a conversation between Mr. Finray and Mr. Kang. Mr. Kang added that claimant has not yet paid the damages for the amount of $1 million. In fact, claimant has paid 70% of the damages and has not been able to pay the rest since respondent refused to perform its obligation in the agreement, which is to pay the full price of the train cars. If the council may refer to a case in Cloud Case 676 between Attorney General and Vianini, the tribunal concludes that if the claimant's lack of funds was caused by the opposing party, such as failing to perform its contractual obligations, the tribunal should not require security for costs in the circumstances. Furthermore, in applying Article 17A of the model law, the applicant of the request must first satisfy several strict conditions, in this case the respondent has failed to fulfill. The applicant of the request shall first satisfy that there is harm not adequately repairable by an award of damages is likely to result if the measure is not ordered. The harm that respondent claims is the legal cost and the arbitration expenses. However, such harm did not qualify as the harm stipulated in Article 17A. In accordance with the working group of the model law, Article 17A covers, first, the harm that is irreparable monetarily, second, harm that can be repaired monetarily but would be comparatively complicated to compensate. It is clear that legal costs can be repaired monetarily. Therefore, there is no such harm not adequately repairable by an award of damages as the respondent claimed. Moreover, in granting any interim measure, the tribunal should take into account the relative financial position of the parties, and this by considering the proportionality between the advantage taken by the party requesting the interim measure and the possible injury caused by such request. Respondent's order for security for costs will lead to additional procedural steps that resulted in additional costs. Consequently, granting security for costs will lead to more damage to claimant. Members of the tribunal, since the claimant has suffered from losses due to respondent's non-payment, it would not be fair for the claimant to provide security for costs as well. Therefore, although the tribunal holds power to order security for cost, the claimant submits that the tribunal should not grant respondent's request since it does not fulfill the necessary requirements under the applicable arbitration law. Members of the tribunal, if the council may be of no further assistance to the tribunal, the council will now conclude the submission. Thank you.
Thank you, counsel. Do my fellow arbitrators have any further questions for
No, thank you.
I have a
Morales?
question actually for counsel for claimant. Yeah, in regards to the proportionality test that you apply, can you be more specific on how would you compare and contrast the harms suffered or incurred by you as the counsel representing claimant and respondent? Because based on Article 17A of the ancestral model law, the lex arbitri of the present proceeding, well, it must be proven that if the measure is not issued, the interim measure is not issued, then the harm will be incurred substantially by the respondent as the requesting party. So how would you compare and contrast it?
Mr. Arbitrator, claimant is now suffering from the outstanding payment due to respondent's non-payment, and by requesting security for costs, it will cause more damage to claimant's financial statement. And as the council has referred to case 676, the tribunal concludes that if there is a lack of funds in claimant's financial statement that was caused by the opposing party, which is the respondent, the tribunal should not require security for cost in the circumstances because it would not be fair for the claimant.
Okay, that is
Thank you, Mr. Arbitrator.
Okay, we're going to respondent rebuttal, I think.
Thank you, members of the tribunal. The counsel for respondent will now submit its rebuttal for the procedural issues. First, that the opposing counsel had wrongly applied provisions located on the UNCI trial model law by relying on the Article 17A alone. But members of the tribunal, we know from Article 2A of the UNCI trial model law, we shall not consider its provisions of UNCI trial on its own, because in fact, we need to consider its international origin. And with this, we will come into a conclusion that our client indeed fulfilled the prerequisites in applying for a security for cause, and that the tribunal shall grant our client's clear assertion for the request for security for cause. And this will conclude the council's submission for the rebuttals. Thank you, members of the tribunal.
I have a question here, Orlis.
Yes.
You invoke the international character. How does that work out in practice? What would be considered in line with international practice and what would not be in line with international practice?
Well, seeing as my time has elapsed, may the council be granted an extension of 1 minute?
Yes, that is allowed.
Yes. So, Mr. Arbitrator, to answer your question, in applying for the Article 17A of the UNCI trial model law, which requires standards for security for cause, we need to also consider the Article 2A of the UNCI trial model law, which is its international origin. And Mr. Arbitrator, the working group of the UNCI trial has believed that the creation of the Article 17A was to avoid any party being able to avoid any enforcement of an arbitral award. And the council will submit that claimant in this presently will shows in its incapacity to pay any future cost award, Mr. President.
I don't see the international characterization there. How would it be different from a domestic dispute?
Yes, Mr. Arbitrator, to answer your question, in fact, the Article 2A of the UNCI trial model law requires the provisions to be applied in accordance with its international origin, and therefore the council submits that the working group of the UNCI trial, the drafter of the UNCI trial, has believed that the creation of the Article 17A was to avoid any party being able to avoid any enforcement of an arbitral award, Mr. Arbitrator. And that shall conclude my submission. Thank you, members of the tribunal.
Okay, thank you. We move to rebuttal. Claimant.
Members of the tribunal, the council will now address the rebuttal. Respondent submitted that the UNCI trial regulates security for cause as an interim measure. However, respondent did not apply the threshold provided in the UNCI trial model law, which is to prove that there will be a harm that will not be adequately repairable by an award of the damages. Hence, we submit that the tribunal should highly consider claimant's submission, as we have proved according to the UNCI trial model law. This concludes the council submission for rebuttal. Thank you.
I can't hear you. What was your last sentence?
My last sentence was, hence, we submitted that the tribunal should highly consider claimant's submission, as we have proved accordingly to the UNCI trial model law, Mr. Arbitrator. Thank you.
Thank you. Okay, that completes the submissions on the procedural side. We now go to the merits of the case, especially on the fixed exchange rate. And again, it's claimant who will now address this issue. Please go ahead.
Good afternoon to all the honorable members of the tribunal. My name is Sarah Melania, along with my co-counsel before this esteemed tribunal today on behalf of our client, and I will now present our arguments on the merits of this case with a total time of 12 minutes. Allow us to emphasize the primary reason for our client's presence here today. They are seeking outstanding payment from respondent. This brings us back to contract negotiations That time, to address price uncertainties and meet both parties' requirements, the PSA was structured on a cost-plus basis with risk-sharing elements. This formula offered respondents assurance regarding the minimum and maximum prices of the train cars, while still allowing our client to recover our cost and generate profit. With respect to the merits of this case, claimant would like to submit 3 submissions. First, that the fixed exchange rate does not apply to the whole agreement. Second, respondent has breached the contract by failing to pay the outstanding amount. And third, claimant is entitled to compensation for the cost incurred in this arbitration. Arriving at the first submission regarding the applicability of the exchange rate, we will divide it into 3 main arguments. First and foremost, that both parties intended to use the default rule in accordance with the applicable law, followed by that the exchange rate is governed by adroit principles, and that the main purpose of the addendum is to solely regulate the additional features. In our first argument, we recognize that this dispute arises because of the different interpretation on the fixed exchange rate provision in the addendum. Pursuant to Article 8 of CISG, we would like to emphasize the importance of interpreting this agreement based on the parties' intention. To support this, we would like to draw the tribunal's attention to Cloud Case 1039, in which the court applied Article 8.1 of the CISG in regards of interpreting the contract concerning the specific features that the machine in the case question was required to have. This highlights the application of Article 8.1 of the CISG, recognizing subjective criteria for contract interpretation that could help us in inquiring the true intent of the parties.
Counsel, you're referring to a court case law, right? Is that an arbitration case, counsel?
This case was governed in the Navarra Provincial High Court.
Right,
as
it's a
arbitrator.
court case. So why should this tribunal be persuaded by a decision of a domestic high court case?
If I may refer to BANI Article 15.2 regarding contract stipulations, in applying the governing law, the tribunal shall take into account the provisions of the underlying agreement as well as relevant trade practices and usage. Hence, this case, we can refer it as it has this kind of similarity that we could apply in our case.
So solely because of similarity of factual matrix or legal matrix, counsel, and that's why you apply that case to the present case? Is that it?
We would like to submit that we use the same interpretation as the court regarding the same legal provisions in this case, which is Article 8 of CISG. Hence, we would like to submit that we should use this case as a consideration in determining the end result. Moving on with my submission, if I may refer the tribunal's attention to page 32 and question number 7. On the second sentence, which starts, the discussion regarding the risk-sharing element has been done, and that the parties has agreed that there is no major risk that will happen. Now, this implies that including a specific provision regarding the exchange rate was deemed unnecessary. In conclusion, the absence of an exchange rate provision serves as a compelling evidence that respondent intended to adhere to the default rule as per the applicable adroit principle, to which this principle dictates using the prevailing exchange rate at the time of payment, which we will further explain in the next argument.
Counsel, can I just ask you about one element of the intention of the parties, that regardless of their initial intentions under the main agreement for the trains, the SPA, as it was originally executed, there was exchange of notes between Rihanna Rails and Nixon as embodied by R2 and R3, respondents exhibits R2 and R3, which indicate that there was an interest in talking about fixed exchange rate, presumably in the context of the entire agreement, because Exhibit R2 was issued before even the additional components were agreed. Do you have any submissions on how that applies rather than, if we even accept that, the initial negotiation of the whole agreement, yes, maybe that was agreed to be on whatever the exchange rate at the time, but the addendum has a different meaning. Can you please address that?
We would also like to submit in accordance to the Cloud case, which emphasizes that when interpreting the contract, the court must consider the factual matrix, which is the background and circumstances existing at the time of contract formation, and in this case, existing at the time and contract formation of the addendum. In Respondent's Exhibit R3, it is very clear that respondent only intended to apply the addendum to regulate, if I may rephrase it, it's clear that respondent has shown their intention to only regulate the additional features within the addendum, and our client has clearly understood respondent's intent of it, which comprehends that our client only used the fixed exchange rate to the additional features. In addition, respondent argued, or respondent has drafted this addendum 10 months after the first agreement has been entered, and at the time, 90% of our train cars has been produced, which in this case is almost 100% completed. And if we were to use the fixed exchange rate, then our clients won't be able to recover their costs, which was the first main objective intended in the main agreement.
Counsel?
Yes.
On page 20, it's on the addendum wording, says other terms as per the main agreement and the exchange rate for the agreement. So how do you explain the difference between the main agreement and just the agreement? How
Well,
should the tribunal view this difference?
thank you, Mr. Arbitrator. To confirm with your suggestion, it is correct that there is a statement regarding states other terms as per the main agreement with capital A, while in the following sentence, it states the exchange rate for the agreement with smaller capital A is fixed at USD1 to 131. Now, this could implies that the main agreement with capital A refers to the original agreement signed by both parties on 18 March of 2022, while the next word of agreement with smaller case A refers to this addendum, which further supports our client's intention to apply the fixed exchange rate only to the additional features.
Counsel, why should we accept your understanding that the lowercase a agreement only applies to the addendum? Isn't it equally plausible that the lowercase a agreement would apply to the main agreement plus the addendum? Like, is there no ambiguity there?
Yes, indeed, Mr. Arbitrator. As there is an ambiguity in the addendum, we would like to submit that the contra preferendum rule shall prevail in this case, and that we should interpret the agreement against the party who drafted this addendum, which is respondent.
And what is the legal basis for you to say that it should be interpreted against the respondent that's relevant to this case?
Well, the contra preferendum rule is regulated under Udroit Principle, Article 4.6, which states if contract terms supplied by one party are unclear, an interpretation against that party is preferred.
Counsel, you mentioned about the Udroit principles, but isn't CISG to be applied to the PSA here and not the Udroit principles? Are you saying that there is a lacuna within the CISG such that you have to apply the Udroit principles?
Indeed, Mr. Arbitrator. In accordance with the records of our PSA and Article 20 regarding the choice of law, it is stated that this agreement is governed by CISG, and for issues not dealt with CISG, the Udroit principles are applicable. And we found that if the tribunal has found that the intention of the parties regarding this addendum is not discernible, then we should use the contra preferendum rule as in accordance with the Udroit principle.
So, Counsel, can I have a follow-up question from my co-arbitrator in regards with the UNIDROIT? In that case, and revert to the contract, what is the status of the UNIDROIT in this present case? It would be kind of the soft law or hard law? And also based on your previous argument about the unit draw.
Well, if I may refer tribunal's attention to page 29, subsection 3, for question number 3, it is undisputed that the general contract law of all 3 states, which is Beatrix, Rihanna, and Costa Nomica, is the verbatim adoption of the Adroit principles on international commercial contracts.
So you're not answer my questions, counsel. Unit draw in this case is soft law or hard law, if I may refresh my questions.
We would like to submit that it's a hard law in this case. Moving on to our second submission, we would like to present our case on respondent's breach of contract by failing to pay the outstanding amount. Members of tribunal, as I see that my time will elapse soon, can I request for additional time?
Yes, that request is granted.
Thank you so much, Mr. Arbitrator. Moving on with our second submission regarding respondent's breach of contract. The PSA clearly stipulates using the exchange rate at the time of payment. Our client has fulfilled their obligation by delivering the goods as agreed. However, respondent's failure to pay the agreed price of $1.2 million constitutes a breach of Article 53 and 62 of the CISG. In conclusion, respondent's refusal to pay the outstanding amount is clear breach of contract. Lastly, to conclude the merits of this case, our client is entitled to compensation for the costs incurred in this arbitration. In accordance with Article 61 of the CISG, if buyer fails to fulfill their contractual obligations, then seller has the right to claim damages under Article 74. In the case,
the trains that were delivered, did they include the additional features, the foldable table and the socket?
yes, our client has fulfilled all of their obligations, including the modifications that respondent has requested.
Where can we see that in the record? That they've delivered the trains with the additional features?
I would like to refer the tribunal's attention to page, one moment, if I may press one of my records. Here in page 10, Exhibit C3, it reveals that respondent has delivered the product and paid a partial payment to the invoice. Hence, respondent, sorry, Mr. Arbitrator. And in this case, the tribunal also asserted that a party who through their own omission knowingly causes damages to other party must compensate for the foreseeable harm inflicted. Respondents should have foreseen the harm resulting from their failure to fully pay the agreed price. Consequently, claimant has the right. Yes,
You should
Mr.
come to a
Arbitrator.
conclusion now.
Yes, it's my conclusion. I apologize. Hence, our client has the right to request compensation for the financial losses and the course of these proceedings. This concludes claimant's submission. Members of tribunal, if the counsel may be of no further assistance, the counsel will now proceed back to the bench. Thank you.
Thank you, claimant. We now move to respondent on the merits.
Yes, thank you, Mr. Arbitrator. Good afternoon, members of the tribunal. My name is Alicia Hadiutomo. As my co-counsel had already spoken about our client's request for security for costs, I shall now establish the first issue of the merits regarding the whole application of the fixed exchange rate. I will address the issues in the following order. Firstly, claimant agreed to the entire addendum language. Secondly, there is no ambiguity in the addendum's wording contrary to opposing counsel's claim. Thirdly, applying a fixed rate was reasonable given the sales transaction volume. Lastly, our client aimed to reduce currency risk for both parties. Turning then onto the first issue, members of the tribunal, allow me to invite you to page 19 of the record. Now, if the tribunal is with me, This is where our client's first email is located. This email was sent to notify claimant of the discussions conducted by our client and its House of Representatives, and also to rely their intention to fix an exchange rate for this contract in order to reduce the risk. Unfortunately, both parties ultimately forgot to conduct a meeting discussing this issue. It was also in this context that the opposing counsel had asserted that this email has not been replied with, and therefore, pursuant to Article 2.1.6 of the Unitary Principles, claimant's silence or inactivity shall not amount to any forms of acceptance. However, members of the tribunal, we will assert otherwise. Ultimately, the email sent by respondent located on page 19 of the record was only unreplied, but well received by claimant. Our submission is not that the claimant agreed to the email's intention, but rather our client's addendum indicated their intention to apply a fixed rate, which was initially overlooked. According to Article 29 of the CISG, a contract may be modified or terminated by the mere agreement of the parties. And in this case, the addendum was meant to modify the parties' common intention and introduce the fixed rate. To prove that and also to analyze the exact wording of this addendum, allow me to invite you to page 20 of the record. Now, if the tribunal is with me, this is where our client's proposal for the addendum was located. Here, it's clearly stated in the first paragraph of the email, and I quote, "As already discussed in the previous meeting, that the best way to reduce the risk for us is to fix the exchange rate." Members of the tribunal, this shows how respondent had also included its clear intention to apply a fixed exchange rate for the whole contract in its proposal. In accordance with Article 8 of the CISG, for example, where claimant must interpret the proposal and other conducts of respondent in a way that would reflect our client's intention where claimant knew or could not have been unaware of that intention. Ultimately, members of the tribunal, Article 19 of the CISG recognizes the rights of an offeree to either add, limit, modify, alter, or ultimately reject an offer if the claimant had found the addendum to contradict with their intention materially. Claimant, in this case, being aware of our client's intention in applying a fixed exchange rate for both contracts, should have read in line with our client's intention.
Counsel, you mentioned both contracts. What do you mean?
I'm referring to the addendum and the main contract, Mr. Repeater.
Okay, so please be specific because it might be confusing because we are talking about one contract.
Yes, my apologies.
Counsel, follow-up question from my co-arbitrator's question. So are there two contracts here, or is this part of the same contract, the addendum?
There is only one contract, Mr. Arbitrator. However, the addendum was made to modify the contract.
I have a question there, counsel. What was the reason that you chose for an addendum rather than from an amendment of the main contract? Because you were in charge of drafting, so you were also in charge of choosing or making a choice between those options.
If I may have a moment, Mr. Arbitrator. If I may answer that question, it was pure convenience, Mr. Arbitrator.
Say that again, please.
Pure convenience, Mr. Arbitrator.
Convenience. Okay. Thank you.
Thank you, Mr. Arbitrator. Now, ultimately, members of the tribunal, Article 19 of the CISG recognizes the rights of an offeree to either add, limit, modify, alter, or ultimately reject an offer if the claimant had found the addendum to contradict with their intention materially. And claimant, in this case, being aware with our client's intention in applying a fixed exchange rate for our contract, should have read in line with our client's intention.
Sorry,
Now,
the claimant earlier argued that the intention, that the effect of the interpretation that the respondent wants to take would deprive them of any profit of the main contract. Is there any reason why you think they would have agreed to that if it applied to the main contract as well? I mean, it would be a strange commercial outcome, would it not? Again, we've established earlier that there's ambiguity in the difference between capital A agreement, lowercase a agreement, the agreement. Nobody really knows, but if you were to look at all of the factors, one of them must be that to adopt your interpretation would mean that the claimant agreed not to have any profit.
yes, Mr. Arbitrator, to answer that question, our client had already sent an email, and our client had showed their intention to fix the exchange rate was due to the fluctuation risk, Mr. Arbitrator.
But at the same time, Counsel, you admit that there was never a discussion about the fixed exchange rate. So again, wouldn't that be more of it's an unknown area for the claimant, but maybe the intention of the respondent was consistent, but is there a meeting of minds? Is there anything you can point at to say, oh, of course, they must have agreed to the fixed exchange rate applying to the whole agreement?
Yes, Mr. Arbitrator. Claimant, by sending us the invoice, should have showed their intention that it was in line with our intention. And in this very particular circumstance, the reasonable person in this circumstance had already used the fixed exchange rate accordingly with the addendum, and that shall show their intention, show that their interpretation is correct, Mr. Arbitrator.
I mean, where do you find this reasonable person test that we are supposed to consider here?
Their accountant, Mr. Arbitrator. Their accountant is the reasonable person. And also, by making an invoice, it should have gone through the CFO's approval, Mr. Arbitrator.
Thank you, Counsel.
And in this, yes. Now, if I may return to my submission, the stable exchange rate from US dollars to BRICS over the past 10 years supports respondents' efforts to mitigate currency risks for mutual benefit. The opposing counsel's argument about the decreased value of US dollars and the new currency, BRICS, is valid, but overlooks the broader objective of respondent, in reducing risk. The fact that an exchange rate that has statistically been stable for over 10 years is able to drop unprecedentedly, it could also, by using this logic, fluctuate even further in a way that might be disadvantageous for neither parties. Therefore, members of the tribunal, there is an increasing need for a fixed rate.
Counsel, how would you respond to the proposal of the opposing counsel that the contra preferentum principle as an interpretation of a contract needs to be applied here? Should the contract or the addendum be interpreted against you, counsel?
Well, Mr. Arbitrator, we do not agree that the contra preferentum rule should apply here since there has been no ambiguity.
Right. So are you saying that the Undroit principles as the governing law of the contract should not be applied? Why is that, counsel?
There has been no ambiguity, Mr. Arbitrator. Therefore, the contra preferentum rule should not apply to this very arbitration. Now, if I may resume to my submission, the whole application of the exchange rate leads us to the second issue, which pertains the allegations of breaching Article 53 and 62 of the CISG. In accordance with Article 8 of the CISG, the interpretation of the contract indicates a mutual intention of both parties to apply a fixed exchange rate of 1 to 131 bricks for the train cars. As Article 53 of the CISG that has explicitly outlined their responsibility to pay the price for the goods and take delivery as specified in the contract. Members of the tribunal, allow me to take you to page 9 of the record. It is stated under the addendum that the exchange rate is fixed at 1 to 131. Therefore, they have made timely and complete payments as required, ensuring that claimant received the agreed upon price for the goods. Consequently, there is no outstanding payment. Respondent has diligently fulfilled their obligations and not breached the contract. Claimant's failure to provide compelling evidence undermine the validity of their argument. Given these circumstances, I respectfully request the tribunal to carefully consider these points in their deliberations and rule in favor of the respondent. Thank you.
I have a question here, Counsel, and it comes back to a point which we discussed earlier. It's clear that the addendum is made because of the additional features. It's also clear that the PSA had already been signed. What would you say to the argument that because the addendum only related to the additional features, a reasonable interpretation would be that the clauses therein, especially the exchange rate clauses, would also only apply to additional features?
Yes, Mr. Arbitrator, if I may have a moment.
Yes, you may.
Thank you. Seeing my time has elapsed, if the council may request for an additional 1 minute.
Yes, I give you time to answer this. 1 minute.
Thank you, Mr. Arbitrator. Now, based on the understanding of a reasonable person in a similar circumstances, the transaction volume of the train cars greatly outweighs that of the additional features, indicating respondents' intention to reduce currency risk for both parties. Thus, a reasonable person would not interpret the partial application of the fixed exchange rate as significant compared to the overall contract. Mr. Arbitrator.
Thank you, Counsel.
Thank you, Mr. Arbitrator.
Your time is up, and I don't think you need any further time. Are you asking for further time?
No, that should be enough, Mr. Arbitrator. Thank you.
Thank you. Okay. Now we go to the rebuttal, and the floor is to claimant.
Thank you, Mr. Arbitrator. Members of the tribunal, we would like to submit 2 arguments for our rebuttal regarding the merits of this case. In this situation, the fundamental principle of good faith and mutual benefit in business agreements will not be upheld if the fixed exchange rate is used. Although both parties initially intended to enable our client to recover their cost, this objective was not achieved with the implementation of fixed exchange rate, leading to financial losses as our client could not meet their production expenses. Moreover, in accordance with CRSG requirement and as seen in the relevant cloud case 592, respondent's intention to incorporate and implement the fixed exchange rate must be evident to our client. However, in this case, respondent failed to demonstrate such clear intention. Hence, it can be concluded that the prevailing rate at the time of payment shall be applied. This concludes our submission for the rebuttal. Thank you.
Respondent, your rebuttal.
Yes, Mr. Arbitrator. The opposing counsel had argued that the respondent is not acting in good faith, Mr. Arbitrator. However, respondent had actually, my apologies. Respondent had indicated their intention in applying the whole application of the fixed exchange rate. And it is also in accordance with Article 14 of the CISG. Claimant has the rights to either add, limit, modify, alter, or ultimately reject an offer. But claimant in this case did not do that. Hence, by sending us the invoice, claimant has indicated that they had accepted the application of the exchange rate as written in the addendum. And that shall conclude my rebuttal. Thank you.
Thank you very much. Co-arbitrators, do you have any questions
Nope.
left?
I think
If
so.
not, okay, if not, then I conclude that these proceedings are now closed, and I will give back the floor to the bailiff.
Okay, thank you, Mr. President Arbitrator. Now the oral presentation is now over, and the arbitrators now will deliberate to discuss each score in the breakout room. And for the operators, please proceed to move the arbitration to the breakout room for deliberation. And for the participant, you may stay in the main room to wait for a feedback session, and the arbitrators will return to the main room after the deliberation. Thank you.
Thank you, arbitrators and bailiff.
Thank you, members of the tribunal.
Thank you, members of the tribunal and the bailiff.
Thank you.
We seem to still have an oralist with us.
Two of them.
Oh, okay.
Three of them.
Three. No, I'm afraid you'll all have to leave. Yeah.
Enthusiasm.
My apologies, honorable judges. You may now enter the deliberation chamber. I believe the operator has assigned you to that chamber, so you may now enter deliberation chamber. Thank you very much. Mr. Baker and Mr. Reed, do the both of you have any problem in entering the chamber, or?
What do we have to click? Do we just leave? Do we click leave?
Oh no, on the bottom of the screen there should be breakout rooms.
Not on my screen.
All right.
Not on my screen.
All right. We will try to reassign you to the chamber. Can the operator please help to assign both Mr. Becker and Mr. Reed to the chamber?
The only option I have at the moment is to leave. There's no. Oh, here we go. I just got it now.
Right.
Recording stopped.
Okay, now because all the arbitrators are present in the main room, before starting the feedback session, I would like to confirm if the claimant side and the respondent side from the final round are here.
So bailiff, can we start with our feedback?
Before the feedback session, I would like to confirm for all the delegates to be present here, Mr. Baker.
So we will wait for you.
Yes, I think we may wait for the delegates to be present and in this feedback session because there is no confirmation from the delegates that they are here now.
Okay, we'll
Claimants are here. Thank you.
Respondent is here, Bailiff. Thank you.
Yes, and for the claimant, are you here now? Okay, because both of the respondent and the claimant side are here, the feedback session will start, and I will give the floor to the presiding arbitrator, Mr. Baker. You may take the floor. Thank you.
Good. Thank you, bailiff. This is the time to give you an assessment. We can't give you the results, but we'll give you an assessment. And we've chosen to do this by team rather than by individual. That has a good reason, because we thought both members of each team were almost equally talented and brought up the right points. Together with the fact that both teams were also very, very, very close, it made us quite a difficult choice for us. But I think the feedback can be useful nevertheless to point out some of the things that I really enjoyed in both teams. First of all, you were very complete in dealing with all the subjects that jumped to mind in this case. The case wasn't easy, and the fact, the lack of factual information given to us and to you wasn't always as complete as we might have hoped for. So there was a lot of interpretational differences, but there were also, of course, the legal considerations, and I feel that both teams were there completely in possession of the case. I think you knew your facts extremely well. It's clear, and I've said this before, that you spent a lot of time on this and you are completely familiar with the issues. What I liked about all teams, they had good eye contact with us arbitrators. You looked us in the eyes. You didn't let us go, which is very important. All of you were free from paper. You hardly ever looked down on your paper. That also gives me a feeling of confidence that you were completely in charge of what you were saying. You were very, very good in responding to the questions. Not all of them, but the essential ones for me, I think you did very adequately. You didn't go into discussions on the subject where you felt that an arbitrator was not on your side, which is very smart, because you tend to irritate an arbitrator if you continue arguing with him on a point that he doesn't agree with you. Your body language is good. I like the way you used your facial expression to stress a point when it was necessary. And where necessary, you also used your hands. So, yeah, I think we saw a extremely well-trained set of teams, and there isn't really much that I can say here to criticize you, because there wasn't any room for that. We don't have to give you recommendations because there's no next round. So I guess you will just be very interested in hearing the results. Rita, would you like to add stuff to that?
Okay, thank you very much, Presiding Arbitrator, for the opportunity. First of all, I would like to congratulate for both teams. Both teams do the very wonderful session, especially for this final round. I believe that after the long preparations, this day is something that you are all waiting for, and not all the team has an opportunity in this round. And I believe it's because your hard work and the serious preparations, both on substance and also the way you address the argument. I will give the general comment for all the team. First, for the respondent, I think you are both speaker very very perfect to deliver the argument. Especially Marvel is quite calm and very even calm, but you're serious to respond all the question from all the arbitrator. And also for the second speaker, even you look struggle to answer the questions, but I think it's really hard work, I think it's good. And I think for the substance, because in the contract, especially for the arbitrations, there is a law difference for the substance, for the contract itself, and also for the arbitration or the arbitrations proceedings. I think both team, you will be attention on that substance, on the law for the contract and the law for the arbitrations. You have a very good in the eye contact, and Marvel, you have a good way to trying to engage with all the arbitrator. I think that's the first point. And for the claimant team, I'm quite entertained by your team, and especially for the second oralis. Yes, you answer the questions in a good way, and I think in the strong argument, even in the simple response, but you are straight to the point, and trying to back to the substance in a good way too. And I think you have a very strong argument and a strong preparation in the way you deliver your arguments. And for the first speaker also, you have a good smile. And I think even this not a very substantial in the arbitrations proceeding, but I think this is also one of the strategy that the arbitrator trying to have, or you want to attract the arbitrator to give a concern in your argument. I think that's good. Thank you very much, Presiding Arbitrator.
You're welcome. Glenn, would you like to give your views?
Yes, thank you, Mr. Presiding Arbitrator. First of all, I would like to introduce myself. My name is Glenn Wijaya. I'm a practicing lawyer at Christian Teo and Partners. I used to participate in the VCs in 2016. So I have some background in international arbitration. I've judged several times, I think Mochtar and other arbitration competitions, including the VCs. So in terms of the performance today, I think both teams exhibit impressive performance. But I must say that there are some notes that you should take moving forward. For example, the common pitfall. You might rely on a how should I say, like a specific scenario. You don't really go out of the scenario you've put in your notes. I see that sometimes you read from your screen. I don't really recommend that, because I see that most winners in other competitions, for example, from Singapore or other common law jurisdictions, they try to leave the notes behind. They just think on their feet, right? And rely on the dynamics, not really on the notes, because that's what most Indonesian teams do. They make notes based on the seniors' input and the coaches' input, and that's it. They don't really try to break through. So that's number one. And my second input would be to try to think that this oral round as a dialogue rather than a speech, because that would help us understand more, and it would seem like a more natural arbitration rather than a speech, because that's not the point here. We are asking questions, and if you think that you need some time to think, then give some time to think and consider our questions rather than simply, okay, I don't have it in my text, so that's it, and we just escape from that predicament. And my third point is that even if this competition, perhaps you think that, okay, this competition is not that easy, or it's not that useful for my law school progress moving forward, I must say that doing a moot competition is really beneficial to get a taste of legal practice. You get a taste of dealing with your classmates or peers from other batches, and dealing with coaches, dealing with foreign counsel, dealing with arbitrators. Later on, when you work, you'll deal with judges, bailiffs, etc. So I think if you have the time and determination, you should try to join other competitions. And I really recommend all of you to join the V's, at least the V's East, or if you have the time and the money, then go for the V's West in Vienna, because that would be the grand slam of arbitration. I think that's all from me. I wish you all the best luck and wait for the announcement. Thank you.
Rita, I hadn't given the opportunity to you to introduce yourself.
Yeah, quite yeah, I forgot to introduce myself. Thank you, Mr. President Arbitrator, for the second opportunity for me. Hello, my name is Prita. I'm the head of the Transnational Business Law Department and also a chairwoman for the Association of the Academician and Practitioner for Arbitration and ADR in Indonesia. Good luck, everyone. Thank you.
Good, thanks, Rita. William.
Okay, thank you for the floor, Mr. Presiding. Hello, everyone. My name is William Chindrawa. I currently work at Ginting and Rexodi Putra Law Firm in association with Ellen and Overy LLP. I have been Mochtar just like you back then when I was still in law school, joining FDI Moot and other arbitration moot court competitions. And other than that, I was also invited as a judge for FDI and FIS moot court competitions in 2022. So I have vast experience in moot court simulation competitions, especially in the private, on the field of private international law. So first and foremost, I would like to congratulate to both teams for their outstanding performance. To be frank and to be candid with everyone here, it is a very tough decision to make because all of the arguments presented by both teams are spectacular. We are very, very appreciative of the arguments that you have presented and the responses that you make to the opposing counsel's arguments. That is an impressive feat in and of its own. Now, in regards to my general feedback, unlike my co-arbitrators here, I'll just be giving a general feedback for both teams directly. And this is something that I find missing from both of the team submissions. So at the procedural stage, you would always have a responding oralist. And for this moot, it will be the claimant as the responding oralist. It will be great as a responding oralist, be it at the procedural stage or at the merit stage. So for merits, it will be respondent to really respond to the questions raised by the opposing counsel in their submission. So how do you do this? Well, you have to note down all of the arguments and try your best to contest every one of those arguments, be it relevant or irrelevant, because as a responding oralist, your job is to debunk, to rebut the claims made by the opposing counsel. So I think that's what I find missing from both teams' submissions, especially for their responding oralists. Now, my second general feedback is that I do understand that as an Indonesian mooter, our biggest struggle is our language, because our native language is Bahasa. So I know that sometimes when it comes to enunciation, oftentimes we made the mistake in pronouncing some of the English words or even the Latin words, basically foreign words that we are not familiar with. So well, to improve on your pronunciation and enunciation, you have to practice. You know, just like the saying, practice makes perfect. The only way for you to improve on your speaking or your presentation would be to, you know, join as many moot courts competitions as much as possible. I share the same view as Mr. Glenn. You'll, as a first-year law student, I assume that you guys here are freshmen. You guys are newcomer in law school, and I believe that you haven't even taken a contract law class yet, and that is very impressive and admirable, because to present your submissions in this moot court, you need to have a basic understanding on contract law. But the fact that you haven't taken a contract law class and you participated in this moot court competition, that in and of its own is very impressive. So I would like to commend both teams on that. That being said, yeah, whenever you have the time to join a moot competition, any kind of moot court competition, be it public or private international law moot court, you'll have to join it, because at the end of the day, it will help you improve on your soft skills and hard skills as an aspiring lawyer or whatever legal career that you're going to be striving for in the future once you graduate. I think that is it from me. Now I'm going to pass back the floor to Mr. Presiding. Thank you.
Okay, Robert, that leaves you.
Last but not least, thank you, Presiding Judge, for the intro and managing today from the bench. And thank you, teams, for a really enjoyable and involving performance, both sides. Compared to my experience yesterday with the preliminary team, who read everything and hadn't digested the law and the context, you guys were a real pleasure to listen to. And I think I have to really reinforce and commend my 4 fellow arbitrators for all their comments, and I, without copping out, want to echo all of them. It's very difficult, as you appreciated, in 11 to 13 minutes for us to properly assess what you're capable of. And when we start interrupting you with questions, literally 50% of your time can get chewed up. So, you know, we have to make a very difficult assessment based on either getting out only a little bit of what you prepared or getting out a lot more. And for me, my questions, you know, although you might not have responded directly, you indicated to me that you had other resources. You had relevant laws. You could come back with a contra proferentem or something to deflect me. And I thought, well, that's actually good. It doesn't answer my question, but yeah, this is a principle that could be applied. So, you know, it's all about confidence at the end of the day. As the presiding judge said, like when you've got eye contact and you're engaging, then we can't help but follow along unless we can think of something to trip you up or challenge you or test you. But, you know, we do that from a point of view of confidence that you can come back, and you did. I suppose there's not that much more that I wanted to say other than, do more moots. My background is I'm currently and have been for the last 20 years foreign counsel with Sumatera and Taher. But before that, I came from Freehills in Sydney, who actually were parties to the paper with the Freehills Herbert Smith paper that was very interesting on the security for costs. And over the years, I'm a commercial lawyer, but in 1987, if you go back that far before you were born, I did the Jessup Moot, and the Australian team won the competition and went to Boston, and we had the second best memorials in the competition, and that kept with us and made us at least to the quarterfinals. But since then, I've been doing a lot of moot coaching for different universities, UI, UGM, and now University 11 Maret. And that's all a lot of fun, occasionally acting as a judge for the Jessup. And I really could recommend do an international law moot, do Jessup or International Humanitarian or the Willem Fiss arbitration. They're all really great. And then you've got the goal to go overseas and see the world, and you come back as heroes. So, that's probably about it from me. Thank you for your hard work. It really pays off.
Thanks, Robert. I guess that leaves a few words to introduce myself. My name is Theodor Bakker. As you may see from my name, I'm a Dutch citizen, but I've been in Indonesia long term, always with Ali Budiarti Nugroho Leksudi Putro as foreign counsel. My main areas in ABNR are, of course, arbitration, and I'm a fellow at CIRB. Like some of the other arbitrators, I've done moot courts, I think 12 years now, and I can only recommend what everybody has said. It's a wonderful occasion to come further in the arbitration world, and also done this. I've also done Jessup, actually, and I went to Washington as a coach for an Indonesian team, and we came pretty far, actually. So arbitration, project finance is another field that I'm active in, aviation, and especially aviation restructuring practice. You can imagine that we've been really busy the last 2 years with the Garuda bankruptcy, which was a wonderfully interesting case. And I should thank all the Indonesians in the room for their hospitality for me over the last 20, 30 years or so. It's wonderful to practice in Indonesia. Congratulations to all. You can have a sigh of relief because there's no next round. You've done it all, and we enjoyed it tremendously. Thank you. Back to the bailiff.
Okay, thank you for all the arbitrators for the feedback. And don't forget to submit the score sheet to the email that is imcc.mochtar@gmail.com. I will wait for the score sheet to be submitted today. And after this feedback session, it means that this is the end of the final round. And after this, I will give the floor back to the MC. Thank you.
Okay, thank you. All right, now that the final round is over, we will now allocate an approximately 2-hour break, and all participants are expected to return again at 4 p.m. Western Indonesia time for the closing ceremony and announcement of the winner. Participants are encouraged not to leave the Zoom meeting. As for the spectators, you may leave the Zoom meeting and only watch the closing ceremony through the YouTube live stream. Thank you.
Thank you, judges. Thank you so much for this opportunity.
Thank you, MC.
Thank you.
Judges. Thank you, everyone.
Thank you.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon and greetings to all participants and honorable guests. Welcome to the closing ceremony of Mochtar Kusumaatmadja International Commercial Arbitration Moot Competition. First of all, I would like to congratulate all participants for finishing the moot competition. We acknowledge that mooting is not an easy thing to do. However, each and every one of you are able to compete exceptionally well, and we hope that this competition would be a precious experience to kickstart your mooting journey. I would also like to remind all participants not to be discouraged. Whatever the results you receive, you all have worked hard for it. Furthermore, I would like to thank Ali Budiarjo Nugroho Reksodiputro Counselors at Law for sponsoring the 2023 Mochtar Kusumaatmadja International Commercial Arbitration Moot Competition. Now, may we start with the first agenda of the event, the welcoming remarks by Kang Muhammad Kunto Triwibowo as the head of Badan Eksekutif Mahasiswa of the Faculty of Law, Universitas Padjadjaran, to give his welcoming speech. To Kang Kunto, the time and screens are yours.
Okay, thank you, Aditya Randi. So first of all, I would like to confirmation that am I audible, MC?
Yes, Kang.
Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Swastiastu, Namo Buddhaya, Salam Kebajikan, Rahayu. Okay, first of all, I would like to send my best honor to the Honorable Brother, the President of Moot Court Society, Faculty of Law Universitas Padjadjaran, Kevin Fazil Dermawan, and also my best honor to all the committee of this meaningful event, Mochtar International Arbitration. So, just for the brief, I would like to say that I'm happy and I'm proud for this event can be held in Faculty of Law Universitas Padjadjaran. I know and I realize that this event is so really meaningful event. We know that arbitration is really changed the game of the law environment. And I hope this event can give many and much more about meaningful and much more about the impact of the law environment. And I think that's all for what I can deliver to this opening remarks. I hope all of you guys can get a lot of meaningful point for this event. I think enough. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.
Thank you, Kang Kunto, for your welcoming speech. Moreover, let us welcome Kang Kevin Fazil Dermawan as the President of Moot Court Society Universitas Padjadjaran to give his welcoming speech. To Kang Kevin, the time and screens are yours.
Thank you, MC. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, and peace upon you. Good afternoon, judges, delegates, committees, all guests, and participants. My name is Kevin Faza. As President of Moot Court Society, it is such an honor for me to speak on behalf of Moot Court Society, Faculty of Law, Padjadjaran University in today's event, the main event of the 2023 Mochtar Kusumaatmadja International Commercial Arbitration Moot. Let me begin by giving a warm welcome to our guest today, the Honorable, the Head of Badan Eksekutif Mahasiswa, Faculty of Law, University, Kunto Triwibowo, to all of distinguished judges of the 2023 Mochtar Kusumaatmadja International Commercial Arbitration Moot, project officer, and all committees, also all guests and participants today. In this opportunity, I would like to express my biggest appreciation to all parties that have contributed to make this event successfully held. Thank you to Ali Budiarjo Nugroho Reksodiputro, IBNR Law Firm, as our sponsors and all media partners that supports this event. Thank you to all judges that consist of well-known lecturers and practitioners for your contribution to adjudicate this competition. Thank you to Faculty of Law, Padjadjaran University, annual events from Moot Court Society. Thank you to all delegates for joining this competition. Congratulations for complete all stages of the competition, from only performing in this competition, really very, very great. I hope that through this competition, which concerning international commercial arbitration, this event will provide you with a meaningful experience in legal practitioners. And I hope this event can be a platform to all from me. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. Namo Buddhaya and may peace upon us. Moot Court Society.
Okay, thank you, Kang Kevin, for your welcoming speech. Now let us welcome Aliandra Hairani as the project officer of Mochtar Moot 2023 to give her welcoming speech. To Aliandra, the time and screens are yours.
All right, thank you, Mr. Adit. Assalamualaikum warahmatullahi. Wait, we're gonna wait for the disruption here. I'm so sorry, participant.
To achieve. Thank you.
All right, I may continue now. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. My name is Aliandra Hairani, and I'm here to give a brief welcoming speech as the project officer of Mochtar Kusumaatmadja International Commercial Arbitration Moot Competition 2023. First of all, I would like to say thank you to Bang Kunto Triwibowo as the head of BEM Fakultas Hukum Universitas Pajajaran, and Bang Kevin Faza as the president of Moot Court Society, Universitas Pajajaran, for the warm welcoming speech. Thank you, Bang Kunto and Bang Kevin, for attending today's competition. Moving on, I would like to give a handful of appreciation to all delegates that has participated in this year's Mochtar Moot competition. I would like to say that if everything, you all have done such an exquisite job and you should be proud of yourself. This competition can be a milestone for another great achievements you can achieve on the future later on. And not to forget, to all our honorable judges, thank you so much for participating in this year's competition. We are so honored to have you, and we are so thankful to have you in this competition. Also, thank you to all the Mochtar staff that has contributed to make this competition went very well. I, as a project officer, is very grateful and thankful for the Mochtar staff. To keep this short, I would like to say best of luck for you, delegates, for the winner announcement after this. And thank you. Back to Mr. Adit.
Okay, thank you, Aliandra, for your welcoming speech. Now, let us all proceed to the most awaited agenda for all participants, which is the awarding session. I will now invite the project officer and vice project officers of this competition, Aliandra, Michael, and Rafi.
All right, back with. Beforehand, this is the final awarding session that I know the delegates have been waiting for, and I'm not gonna make it any longer, so let's get moving to the very first award. All right. The very first award is for the best claimant memorandum. Congratulations, Team 103 for receiving the award of Best Claimant Memorandum. Team 103 from Universitas Diponegoro, your representative may come forward for the documentation session. Please do turn on your camera and unmute yourself so we can have a picture together. All right, congratulations, Team 103. Now we're gonna take a documentation photo. The cue is on me. Wait. And 1, 2, 3. All right, thank you so much, Miss Rosalinda Zora. Next award, is for the claimant memorandum honorable mention. Congratulations to Team 107 Universitas Pajajaran and Team 101 from Universitas Tarumanegara. Congratulations for both of the teams. And now the representatives may come forward to take a documentation photo. All right, I can see the smile. Congratulations. The cue is on me. Wait a minute. In 1, 2, 3. All right, thank you, teams, and congratulations once again. The next award is for the Best Respondent Memorandum. All right, congratulations to Team 107 from Universitas Pajajaran. Congratulations, Team 107. Let's have a documentation photo. The cue is on me in 1, 2, 3. All right, thank you and congratulations once again, Team 107. Next award is the next award is the Oralist Honorable Mention in round 6. Both congratulations to Fatia Harumi from Team 105. Congratulations, Fatia Harumi. You may come forward for the documentation photo. Or the representative of team. Okay, all right. Fatia, Miss Fatia, congratulations. Have a photo in 1, 2. Congratulations, Miss Fatia. Next is another oralist honorable mention. Congratulations to Miss Odelia Damayanti from Team 103 Universitas Diponegoro. Miss Odelia or the representative of Team 103, you may come forward. All right, wait a minute. Okay, the cue is on me in 1, 2, 3. All right, congratulations, Miss Odelia. Another oralist honorable mention. Congratulations to Miss Alicia Hadiutomo from Team 102 from Universitas Tarumanegara. Congratulations, Miss Alicia. All right, thank you. And the cue is on me in 1, 2, 3. Once again, congratulations, Miss Alicia. All right, next. This is the award that I know you've been waiting for again. The next award is third best oralist. All right. Congratulations to Miss Kanza Octavia, Team 101 from Universitas Tarumanegara. Congratulations, Miss Kanza. Let's take a picture and the cue is on me in 1, 2, 3. All right, congratulations once again, Ms. Indra. And next, this is the discussion between the first best oralist and the second best oralist. All right. The best oralist in overall score, congratulations to Miss Sarah Milenia, Team 101 from Universitas Tarumanegara. Congratulations, Miss Sarah. Let's take a picture in 1, 2, 3. All right, congratulations, Miss Sarah. And the second best oralist goes accordingly to Mr. Marcel Limiardo, Team 102 from Universitas Tarumanegara. Congratulations, Marvel. Let's take a picture in 1, 2, 3. All right, congratulations once again. Now, this is it, delegates. This is the very final awarding for me to announce. The first award that I'll announce is the second runner-up of Mochtar Kusumaatmadja International Commercial Arbitration Moot Competition 2023. The second runner-up. Congratulations to Team 103 Universitas Diponegoro. Congratulations, Team 103. The representative may come forward to have a documentation session. Team 103, are you present now? All right. I will take a picture in 1, 2, 3. Okay, thank you, 103, for winning the second runner-up of the Mochtar Moot 2023. Now, this is the moment to decide who is the first place and who is the runner-up of the Mochtar Moot 2023. The first place and the winner, the champion of Mochtar Moot Competition 2023 goes to Team 101 Universitas Tarumanegara. Congratulations. All the representatives may come forward to the camera. Let's take a picture together. In 1, 2, 3. All right, once again, congratulations, Team 101, for being the winner of Mochtar Moot. And then the runner-up, of course, by now, we all know the runner-up is Team 102 from Universitas Tarumanegara. Congratulations. Let's take a picture. The team is on me. The big smile. 1, 2, 3. All right. Thank you and congratulations, Team 101 and 102. Also, Team 103 for being the winner. Next, the very last but not least, is the award of Spirit of the Moot Award. This award is for the team that shows its effort in competing in this competition. This team not only almost make it to the semi-finals, but also achieved a quite high rank in the memorandum. Let's not make it long. The Spirit of the Moot Award goes to Team 108 from Universitas Kristen Maranatha. Congratulations, Team 108. The representative might come forward so we can have a documentation photo. Team 108, are you present now? Once again, Team 108 from Universitas Kristen Maranatha. All right. I think the representative is not present now. So I'm just by that, it's the end of the awarding session. Once again, congratulations for all delegates. And for that, I'm going to leave the floor back to Mr. Adit. Thank you.
Okay, thank you, Aliandra. Also, congratulations to all teams that received the awards. And I believe we have reached the end of our event. Representing all committees, I would like to thank all parties who are involved in this event, be it our participants, arbitrators, and our sponsor, Ali Budiarjo, Nugroho, Rekso Diputro, counselors at law. On behalf of the entire organizing committee, we apologize if there are words that are less pleasing to the hearts of all attendees, or if there are any mistakes or errors that happen. Hereby, I, Aditya Randi, as the Master of Ceremony, wish you all a pleasant day. Wassalamualaikum warahmatullahi wabarakatuh.